Hi guys, good evening. My name is Sandesh, and first of all, I am really thankful to Mumbai Roadrunners and admins, administrators of the group Mumbai Roadrunners who gave me this opportunity. And I know most of you guys are really these are less than ideal situation for all of us. We are under lockdown for almost, I think, more than 50 days now, and it's we have been pretty patient so far. And but I think we are really going to get through this difficult situation. Uh, on I'm also a runner. I'm also a runner. I'm also an athlete, and I've been part of Mumbai Roadrunners for a long time. I have known most of these admins for a very long time, and I'm really happy that they chose this topic because whether we like it or not, I mean, contract is a part of our day-to-day life. Um, from the time that we wake up in the morning, on social media posts that we do, they all are governed by contracts that we enter into in our day-to-day life. Now, if you're making a post on your social media websites like Facebook or Instagram or on Twitter, you have to comply by the provisions or the contractual provisions which you have agreed to comply with when you became a member of those websites by clicking on these online agreements. I mean, we really do not read those provisions. We simply go there and click I agree on a contract which had in certain races. Many of these races are either cancelled or postponed, and I hope that we get through this very soon and we are back on road, running, cycling, or whatever that we can do. And the topic that I have was given to deal with is regarding the contracts in the time of COVID-19. I have named it as I have named it as contractual conundrums due to COVID-19 because we are coming across various doubts, various questions during these times, and there are various contracts that are really impacting us in the times of in this difficult time during this pandemic. We many of us are employees, many of us are employers, many of us are suppliers, vendors, and entrepreneurs, and freelance workers, whatever you call it. But we are getting impacted by this entire scenario. So how is it going to affect us? I mean, I my attempt will be to keep my this talk and as far as possible I will be doing that. And in the end, after I finish my topic, I'll be more than happy to take up any questions or doubts that you guys have. And even if you do not have I mean, you are not able to think of any questions or doubts, feel free to get in touch with me. Even after this talk, I'll be more than happy to help you out. Now, before I start into various kinds of contracts which I intend to do during this entire this conversation that we are having. I will not say that it's like a webinar, a formal webinar that we are having, but it's more like a conversation that we are having over a cup of coffee or a cup of tea. But it will be important that I give you basic idea. I mean, very basic idea about what exactly is contract. Now, contract. There are two laws, basically two laws that really deal with contract, its performance, and its enforcement. The main being the Indian Contract Act, which deals with what exactly is contract and how it is supposed to be performed and how it can be enforced. Then there is something called a Specific Relief Act, which is basically uh, uh, deals with the reliefs that are available to parties in case their contractual or civil rights are affected. Now, Section 2H of Contract Act defines contract. So the contract is it's a very basic definition. I mean, even in a layman's term, you can understand, but there are different nuances of that definition also. Now, contract is defined as an agreement. The word agreement is very important. Agreement enforceable by law is a contract. Now, the word agreement is also defined under the Contract Act. It is defined as every promises and every set of promises forming consideration for each other is an agreement. So consideration is also defined. So consideration, just to put it in a layman's term, is consideration is basically that what do you intend to derive from a contract. So suppose if I enter into a contract with someone to provide me with, say I enter into a contract with Tata Sky. I want services from a DTH operator to provide, to let me see whatever channels and programs that I'm seeing, or Netflix for that matter. Amount that I'll be paying them for their services. So the consideration flows both ways. So both of us are making promises to each other, and that promise is coupled with a consideration. So that is very important. Now, I told you that the word agreement in contract is very important, because every contract is an agreement, but every agreement is not necessarily a contract. The reason is this: agreement to be a contract, there are three conditions which are required. One is a free consent. Free consent is basically that when you consented for entering into contract, your consent was was an informed consent. You were not coerced, or you were not threatened, or you had the necessary mental capacity to enter into that contract. Second is lawful consideration and lawful object. Lawful consideration, as I said, and lawful object is basically that contract has whatever are the consideration or object for entering into contract, that has to be legal. Now, I cannot enter into a contract with someone for gambling. It is illegal in India, whether we like it or not. Or I cannot enter into a contract for committing theft or committing murder. So those contracts will not be legally enforceable. So that agreement will not be legally enforceable. Therefore, it's not a contract. And the third thing is, it has not been expressly declared void by any law. So therefore, for a contract to be enforceable, it has to be an agreement which is not declared void by by the law. Now, the contract can be oral or written. If there is any oral agreement, that can also be enforced. And there are certain contracts like transactions, property transactions, which are required to be in writing and registered under the law. And even if they are not registered or stamped, but they can still be used for the purposes of what we call it for specific performance of those agreements. There are certain contracts which can be specifically performed subject to the provisions under the Specific Relief Act. As I said, which is another law apart from Contract Act, which deals with the reliefs that can be claimed in case of any breach of contract, or if you want to specifically. Now, coming to the point of COVID-19, now there are certain timelines about the emergence of COVID-19. I'm just referring to some of the notes that I have made, some of the dates. Now, on 31st/12/2019, China reported a pneumonia of unknown cause detected in city of Wuhan to WHO. Now, China reported this on 31st of December 2019. On 22nd of January 2020, the World Health Organization, WHO, issued statement regarding human-to-human transmission of novel coronavirus in Wuhan. On 31/2020, that is January 2020, WHO declared this outbreak as a public health emergency of international concern, which is PHEIC. On 11th of February 2020, WHO announced coronavirus disease as COVID-19. So on this particular, on 11th February, the coronavirus the COVID-19 actually came into picture. There were growing number of cases which people were seeing, across the world. At that point of time, we saw there were cases in Italy, there were cases in Iran, and slowly the India realized that we are not going to be untouched by this entire pandemic. So it resulted into invocation of a very old act, which is called as Epidemic Diseases Act of 1897 by various state governments. This led to shutting down of before the national lockdown actually happened on 23rd March, there were orders issued in, say, state of Maharashtra for shutting down of malls, gyms, schools, and other public places to prevent spread of COVID-19. These were preemptive steps which were taken by state government, government of Maharashtra. Now, 14th March 2020, Ministry of Home Affairs, Government of India notified COVID-19 as a notified disaster. I mean, this has to be done under the Disaster Management Act so that further action can be taken by the authorities. And these are the steps. I mean, they may sound very bureaucratic or very technical, but you have to do this. On 16 March, Ministry of Health and Family Welfare, Government of India, issued advisory on social distancing measures in view of spread of COVID-19, urging the states and union territories governments to take social distancing measure as a preventive strategy for implementation of till 31st of March 2020. And as we know, then there was Janta curfew, and then the Honorable Prime Minister of India was declared the national emergency. The lockdown, which has been extended from time to time, and now we know positively that there will be lockdown 4.0 beyond 18th. Now, this it has necessitated. It was necessitated. I mean, we know that how there is a community transfer that has really been happening due to this entire COVID-19. So, what has been effect of this COVID-19 on our day-to-day life? It has really affected our professional as well as personal lives. I mean, no, I don't think anyone from the poorest to the richest who is not affected by this pandemic. Now, across the world, there is either a partial or complete lockdown. Some people started earlier, some people started later, some people lifted it, then they have again gone back to partial or full lockdowns. Now, restriction on domestic as well as international travel that we are saying, restriction on regular human movements in lockdown that we are saying, and it is happening not just in India, across the world, even in developing as well as least developed countries that we are saying. Domestic and international trade has come almost to a standstill across the world, resulting into disruption of markets and supply chains. I mean, it's across the world we are seeing that it has really affected the markets and supply chain management. Now, it has hurt every business segment as well as individuals at large that we can see, like whether it's a MSME, whether these are small businesses, individual thelawalas, or individual employees. It has affected them. In country like India, like we are before this pandemic came, we were already facing certain difficult economic scene, and this pandemic could not have come at a worse time. This unprecedented situation has affected the contractual performances. I mean, not just for India, I mean across, whether it's cross-border transaction or these are domestic transaction, it has really affected. And people are contemplating what are the reliefs that they really have under the contract, or what are their options, or what are their obligations on the contract, which I intend to cover. Now, COVID-19 has adversely affected, as I said, every aspect, whether it's our personal life or professional life. Now, finance and commerce has been brought to its knees, which is very, very unfortunate, but maybe it is necessitated by the present pandemic to save lives. I think there is the whole argument whether the lives are more important than the economy, or economy is more important than saving lives. Now, performance of contract is affected, and in various cases, it has become impossible. Now, I'll come to whether the impossibility is for a limited time, or it has been rendered for a permanent time. Now, there are two sets. I mean, there are two sets of contracts because of COVID-19. First is that because of this, there is a commercial hardship or burden in performance of contractual obligations. For example, if you were supposed to, because of the lockdown, because you are not able to, if you are a vendor or if you're a supplier, you're not able to supply certain goods or provide certain services, already become very expensive because of scarcity, or they will become expensive after it reopens, or your contract may be providing certain consequences of delay. But in this case, contract has not become impossible. It has there is merely a commercial hardship or burden in performance, and there is a difference, which I'll come to later. And the second form, as I was saying, was rendering the performance of contract impossible to perform, that it's not possible to perform. I mean, suppose if I was supposed to if I was an artist, for example, if I was a musician and I was to do a concert in, say, Jamshed Bhabha Theatre on 15th of April, it's not possible for me to perform. Therefore, the contract has become impossible to perform. So those kind of contracts, the contract is frustrated because you just cannot go on that date and perform. So this is the second type of contract that I am talking about. Now, one thing that you will be coming across as a employee or as a vendor or is a clause called as force majeure, event or act of God. I mean, there is something that I think many of you must be doing some research or reading articles or attending webinars about these contractual provisions. So one clause, the force majeure clause, event or act of God, has suddenly become probably one of the most important talking point in legal circle as well as in commercial and mercantile circles. It's very ironic. It's very funny because when lawyers, especially junior lawyers, are drafting a contract, force majeure clause comes really at the end. One of those miscellaneous clauses, and people tend to ignore. And it's like a copy paste. People just simply say, okay, what is a act of God, riots, and theft, etc., is given to the first few important clauses, like consideration or what money will be paid, what will be the performance, termination, the dispute resolution, etc. So it is one of the most ignored clause in the drafting, but now it has gained importance. So as we say in law, that no clause of an agreement is unimportant. So everything that we see in a contract, every clause has a meaning and it is there for a purpose. It is not there only as some kind of a decorative value in that contract. Now, there is, in common law jurisdiction like India, there is no statute or there is no law which deals with force majeure clause per se. So there is no provision in the contract which deals with force majeure. This is nothing but force majeure clauses are often included in contract, but this is like a bilateral arrangement between two parties when they enter into a contract. What it really does is that it enables a party to excuse performance or absolve a party from liability due to occurrence of certain events that are beyond the party's control. So this is something that, say, we call it as act of God also. So if there is any flood because of which I say 2611, because of which I was not able to perform a contract, so that was act of God on which prevented me from performing the contract. And therefore I was affected by it and I was not able to perform. So this is what the force majeure is. Now, the Black's Law Dictionary, I'll just read, so that you get a context and the meaning. Now, there is something called as Black's Law Dictionary. It's defined as, I'll just read, an event or effect that can be neither anticipated nor controlled, is unexpected, and which prevents someone from doing or completing something that he or she had agreed officially or planned to do. Webster Dictionary defines force majeure as superior or irresistible force, an event or effect that cannot reasonably anticipated or controlled. So what bottom line is that it is an event that parties never contemplated when they were entering into contract, in which they don't really have a control. They do not have a control on floods. They do not have any control over tsunami. They do not have any control in these kind of events. So parties, and in some cases, you can consider the fact that yes, there is a possibility that there will be some natural disaster, but you do not know. Even if you can contemplate it, but you cannot deal with it. So you may put that an event may be tsunami, but fact remains is that you do not have any control over that event. You cannot salvage performance during that kind of natural disaster. So parties may know what that event may be, but it may not be in their control or under the situation in which they cannot really perform the contract. In modern business practices, it is basically embodied in contractual provisions, and it is agreed between the parties to excuse non-performance of contract in case of events which are beyond their control, such as act of God, natural calamities, war, labor unrest, epidemics, pandemics, etc. Now, the words epidemic and pandemic are used in the force majeure clause, then in all likelihood, the force majeure clause is triggered once the contract with the declaration of COVID-19 as a pandemic. So if I mean, this is subject to the entire interpretation of the contract, but if the force majeure clause includes eventuality like an epidemic or pandemic, then you can invoke this clause, and you can really rely on it. Then you will be in a better footing than if you do not have these words in your contract, because eventually it all boils down to the terms of the contract, how you can derive your remedy. Either you can escape your liability or you can enforce the performance from the other parties. Now the test for to seek or rely on force majeure clause is the event that gave rise to a party's non-performance under the contract falls within the definition of force majeure in the contract. That is to say, the event is covered by force majeure clause and the non-performance was caused by that event. So, for example, a pandemic, a riot, a natural disaster like a flood or a tornado, whatever, then event and the non-performance were due to the circumstances which were beyond the control of the party. So it was beyond the control of the party. It was those supervening circumstances in which party could not do anything. Like in present scenario, I cannot do. I'm not able to get out of my house, or my workers are not able to get out of their houses. So it's not possible for me. The next condition is there was no reasonable step that could have been taken to avoid or mitigate the events or consequences. So one of the conditions is when you are invoking this clause is that you have to show that you have taken all the steps which you could have taken to avoid or mitigate possibility for you to perform this contract or a part of contract. Then you have to show that you made that attempt, and despite making that attempt, you were not in a position to perform your contract. Now, the party seeking to rely on the clause may also need to show that it was not aware at the time when it was into the contract regarding this contract, regarding this um, these circumstances will depend upon the factual and legal analysis of contract in question. Entities and individuals are compelled to relook into their respective contracts to ascertain how to avoid liabilities if you are at the receiving end, or to enforce the terms of the contract if you are the one who is entitled to enforce the performance of such contract. Now, companies, any kind of entities, companies, firms, associations, societies, individuals have to ascertain the extent of their liabilities that can be avoided without attracting consequences like financial liabilities, penalties, liquidated damages, damages simpliciter, or if they can be enforced under a contract, uh, or if you are supposed to, if you are a party who wants to enforce it, then under what circumstances you can enforce it under the provisions of law, that is a contract act or specific relief act. Now, uh, if there is no force majeure clause in your contract, then what law says is that you have to look into contract act. Then if you have not performance of act known to be impossible or unlawful, where one person has promised to do something which he knew or with reasonable diligence might have known, and which the promisee did not know to be impossible or unlawful, such promisor must make compensation to such promise for any loss which such promisee sustains through the non-performance of the promise. Now, majority of the contracts especially contain clause according to which contract would will stand suspended or discharged on the happening of certain circumstances or contingencies. In such cases, the dissolution termination of the contract will take place under the terms of the contract itself. So what 56 provides that under certain circumstances, the contract will become impossible to perform. And if it becomes impossible to perform, it becomes void from the date it became impossible to perform. But under section 2, if the party, under subsection 2, if the party which has promised to do an act which they knew or they had reasonable knowledge of ascertaining or knowing that it was impossible or unlawful, and the promisee to whom such promise was made could not have known this, then in that case, the promisor, the person who has made the promise to the other party, may be liable for compensation. That's what it says. Now, second provision that we have to see is section 32, and in fact, Supreme Court in recently in a matter said it is section 32 and not section 56 of the Contract Act, which really deals with the force majeure clause if there is under the Contract Act. Now it is basically deals with contingent contracts. Contingent contracts to do or not to do anything if uncertain event happens cannot be enforced by law unless and until that event has happened. If the event becomes impossible, such contract becomes void. So suppose in your contract you have provided that you to do or not to do a particular act depending upon an uncertain future event to happen, it cannot be enforced till the time that event has happened. So for example, if your contract says that you will not be performing your bargain in a contract in case there is a pandemic, so you are supposed to perform your contract till the time that pandemic takes place. So if the pandemic has come, you may say that, okay, now since there is this situation because of which, and now that's how section 32 gets related to force majeure clause, that since now this eventuality has taken place, therefore I am not in a position to perform the contract. And in that particular case, you can take refuge to section 32 of the Contract Act. Now, once again, the force majeure clause comes into picture when an unforeseen event may render performance impossible only during the limited time. Now, this is very important. Differentiation between a force majeure event or an event because of which the contract has become impossible. So, what really happens in a force majeure event, like say a riot which has taken place, or say a tsunami, or the present COVID-19 pandemic, that the performance becomes impossible only for a limited time during which that event is in operation. And so till the time there is lockdown during this pandemic, you are it has become impossible for you to perform your contract. But after that eventuality or after that event has passed or has taken place, you may be in position to resume your contractual performance. And when that event ceases to take place. So, for example, if at the end of whenever the government says that the lockdown will lift the lockdown, then you may be in a position to perform your contract. You may be in a position to provide the services that you are supposed to provide. You can, so during that suspension period, you can take recourse of that force majeure clause. So it is only for a limited period of time. But in case of impossibility or frustration of contract, that is permanent. So from the date it becomes impossible, the contract becomes void. So there is no question of resuming your duty. So that is the difference between a force majeure and an impossibility of contract. Then it can be used as an exception to breach of contract. So this, if there is any breach of, if you are not able to comply with your contractual provision, it can be used as exception, subject to the fact that the event is covered under the force majeure clause. A party can elect to invoke the force majeure clause in order to excuse itself from the performance, as I said earlier. So one more important thing is that force majeure clause, if applicable, provides limited relief from performance which is rendered impossible for limited period of time, as I said earlier. But it does not allow a party to avoid any contractual payment. So you cannot say that because of this, I will not be making the payments. So if you have entered into commercial lease or commercial leave and license agreement under which you are liable to make a rental payment to the licensor or the lessor, you cannot say that under the force majeure clause, I will not be making the rental payments. So the payment is not excused. The performance may be excused because you are prevented. You cannot say that since, okay, my earnings are lesser and I cannot really, my earnings are affected, I am facing commercial hardship, therefore I'll invoke the force majeure clause and I will not make any payment. That is not permissible. So it does not excuse you from making the payment. As I said, commercial hardship is not it's not a reason because of which these clauses can be enforced. Now, or if, so for example, the goods and services, whatever you are availing, for example, if you are availing services of your electricity or your telephone, you cannot say that you have some financial difficulty because you are not able, therefore you are not going to pay. Whatever services you are availing, if you are liable to pay for that, you have to pay. I mean, you cannot say that it's causing you commercial hardship. Now, it will save you, as I said, from performance of duties which is beyond your control. And as I said, the Supreme Court has now said that Section 32, the contingent contract, which really deals with or under which the force majeure clause can be read into. Now, there is something called as a frustration of contract also. So, this is the other aspect. Contracts enter into become which have been entered into between the parties impose contractual obligation on both the parties for performance of such contract. But many times certain unforeseen events really happen, because of which performance of the contract becomes impossible due to no fault of the either of the parties. For example, I mean, we as law students had this example that if I was supposed to perform, say in again, I'll give you an example of being an artist. So if I was supposed to perform in Tata Theatre tomorrow as a jazz pianist, but God forbids, I mean, just an example, because of some kind of a natural disaster, that Tata Theatre, there is some disaster because of which it gets destroyed. So obviously the basis, the main thing about that contract of me performing in Tata Theatre itself has become impossible. So that itself will render the performance of contract impossible. So the Contract Act does not define frustration of contract, but what it really happens is there is an involuntary extinction of contractual obligation of both the parties. So as I said, I was supposed to go there, or so, for example, that IPL for that matter. So if a particular cricketer was supposed to play for a particular franchise on particular dates, he was contractually bound to do so. But because of pandemic, if the IPL, which is almost cancelled now, he's not able to do so. So that's a frustration of contract that he's not able to perform. So there is no fault of either of the parties, and the contract, there is an involuntary extinction of the contractual obligation on part of both the parties. Now, frustration of contract can be, as I said, for establishing frustration of contract. One is existence of valid contract between the parties. There has to be a valid contract. Contract has to be yet to be performed. I mean, parties are yet to perform it. Performance of the contract has become impossible or void, and impossibility to perform was due to an event which was beyond the control of any of the parties. And as I said, the merely financial hardship of or onerous performance is not a ground for invoking impossibility of frustration or a force majeure clause. Now, the parties have to, I mean, if you are a businessman, or if you are an individual, or if you are an employee, as I said, supplier, vendor, or whatever that you are doing, you have to evaluate the impact of this COVID-19 situation on your contractual obligations, or whatever contractual obligation that you can enforce as a receiver of those contractual obligations. Now, in order to do so, you have to see whether the party whether a party has failed to perform its contract, or the party has been left incapable to perform its contract. The delay that we are talking about, is of such a nature that which really affect the existence of the contract itself. Like, again, coming back to IPL for that matter. I mean, IPL, if it was to happen, say, in April and May, it will be difficult to hold it in, say, June or July, because of obvious reasons of monsoons and the other fixtures that the international cricketers have for their country. So then this delay makes it almost impossible to hold it. The same thing happened for a competition like a Euro 2020 or Olympics for that matter. So the delay really affects the existence of the contract itself. So it will not be possible to hold these events in 2020. Now, since it's not possible, it's cancelled or postponed. Various contracts that were entered into for, say, Euro 2020 or Wimbledon, or a competition like, say, Olympics, Japan 2020, Tokyo 2020, will be affected by it. So obviously, because of this delay, in those particular cases, it has become impossible to perform, at least in 2020 itself. So they will have to look into those contracts in that perspective. Other things you have to see, as I said, again, coming back to whether it's an impossibility or whether it's for limited impossibility or a permanent impossibility, or whether it's just a mere hardship or price rise or scarce availability of raw material extra that you have to see. There is a provision in contract itself which you also have to see in your contract, whether there is a provision in the contract which deals with force majeure. As I said, it's a bilaterally connected, bilaterally agreed term. If there is no such contract, then you have to take recourse of section 32, or if it has become impossible, or then you may have to look into section 56 of the Contract Act. And it have, as I said, it has become impossible under the circumstances which are beyond your control. If the contract provides for consequences of such supervening circumstances, then it will obviously be governed by such contracts. Now, there may be, as I said, there may be a situation in which the contract is rendered impossible to perform due to for an indefinite period, or for a period that you do not really know when it is going to happen. In that particular case also, a party may consider availing frustration of contract, because I do not know till when it's going to last. And again, I can give example of events like Olympics, Euro 2020, Wimbledon, IPL for that matter. One important thing to remember for invoking force majeure clauses, that you have to, the court clause is that you have to give notice to the other party that, okay, now there is this event, like say COVID-19, because of which I am prevented from performing my obligation. So you may have to give notice of this force majeure event to the other party. So you should give notice to the party regarding this event. The clause may require so. Now, party, as I said earlier also, that is under an obligation to make all attempts to mitigate the losses, or to avoid or mitigate the force majeure events, and to show, in order to claim that as its defense whenever it is going to use that clause as its defense, or a recourse to avoid the performance of their obligations. Now, in some contracts, if the period of force majeure is prolonged, if the period is a long, and it's a very short-term contract, the parties may be permitted to even terminate the contract. So if I was supposed to say do certain temporary work, or provide my services for a period of 2 months or 3 months, say consultancy services, but because of this COVID-19, I am not able to do so, the parties may mutually, and in some case unilaterally, choose to terminate the contract with whatever consequences to follow as per the provisions of the contract. Now, the act of God, as I said, force majeure or act of God, I was talking about it. So events like this pandemic. Now, there is whole debate about whether it's an act of God or whether it's a lab created one. That's a different argument altogether. But a natural disaster like flood, tornado, etc., on which humans have either due to these are the events which could not be foreseen, or which are either due to natural causes directly or exclusively without any human intervention, which cannot be foreseen and which cannot be prevented, even if it is foreseen, like, as I said, floods. Now, the recourse that you may have under these, that you can either consider as a party to a contract to either terminate it or renegotiate it. Then parties will have to consider what are the option how to enforce your right under these contracts. So you have to go back and see the terms of contract. If the contract has frustrated or become impossible to perform, the contract would stand terminated, as I said. In case of force majeure, parties will have to consider extent of disability, or the time during which the suspension of performance to seek the appropriate relief that you can seek under that clause. In case of pandemic, as I said, that performance would become onerous or commercially more difficult. In such cases, so as I said, the commercial hardship is not a ground to seek to wriggle out of or try to avoid the performances. In that particular case, the parties will have to sit together and renegotiate the contract. So, for example, like I and many lawyers are getting these queries from various clients. For example, if it's a mall and you are a franchisee of any of these eateries, like say you have taken franchise of McDonald's or Burger King, whatever. See, you are paying commercial rent for that particular premises to the owners of that mall. Now, if for 2 months you are prevented for paying for doing your business, obviously it's going to cause difficulty for you to pay the rentals, the huge rentals, if you have not been able to earn any money. And lots of the mall owners or the owners of the property to consider either deferring the payments or provide them an opportunity to pay that in installment, or are renegotiating the license. In some cases, they are even exiting that premises because the business has become really onerous for them to do so. So parties are sitting and renegotiating. That is the most prudent thing to do right now, because I'll be very honest that to enforce your remedy in court of law, it's going to be difficult in present times. And in future also, what we are going to see is, it will be interesting to see how best parties will be able to enforce their remedies before the court of law. If a contract becomes the other thing is about, if a contract becomes void or is frustrated, there is a principle of restitution under section 65. So if you have received any benefit under the under a contract which has been rendered void, then you are supposed to return that benefit. So that is something that you'll have to consider. You have so whatever advantage that you have received under an impossible contract or a frustrated contract, you may have to return those advantages or benefit that you have received. In case of force majeure, obviously the terms of the contract will follow. The force majeure may provide the right to terminate, suspend the contract during the subsistence of the event, waiver or damages. In certain case, there might be penalty for non-performance or liquidated damages, etc., etc. So that you will have to look into the contract. Now, government has also come out. What I can say is that even government has taken proactive steps. The Ministry of Finance of Government of India has issued an office memorandum of 19 February 2020, in which they have clarified with respect to what is known as Manual for Procurement of Goods 2017, and declared that in the event of any disruption in supply chains due to spread of coronavirus in China or any other country, such situation will be covered in force majeure clause in the contract. It is further clarified that in such a situation should be considered as a natural calamity, and force majeure clause may be invoked wherever considered appropriate, following the due process. Now, the said manual is issued by Ministry of Finance for various ministries and departments, which have delegated their powers to make their own rules and arrangements. Now, similar initiative has also been, like, there is something similar which has been issued by Ministry of New and Renewable Energy with respect to solar project developers. That also, there is an office memorandum of 20th March 2020, in which they have declared that if you miss any contractual obligation due to COVID-19, you can invoke force majeure provision. Now, such kind of, I mean, these are sector-specific provisions which we have to see and which you have to evaluate. But coming from government, it's a kind of breather for the industries or the contractors which are covered by such provisions. So that's an initiative which government has taken, ministries have taken. Now, as I said, there will be a question of dispute resolution. If there is parties are ad idem, or parties have agreed that, okay, we have a problem, so we have to sit together and resolve it. They will sit on a table. They will resolve the issue. They will renegotiate the contract. They will define the terms of the payment, or whatever the terms of the performance during these difficult times, which is most advisable thing to do. But in case they are not able to arrive upon a solution, or are not able to renegotiate the contract as they were required to do so, then there you will have to look into what. So obviously there will be a dispute between the parties, and then you'll have to consider the dispute resolution, how to resolve this dispute. Now, what the parties will have to see that under the contract, whether they have to go before a court of law, or whether there is an arbitration clause in your agreement under which you'll have to go before arbitrator or arbitral tribunal to resolve your dispute under the provisions of Arbitration Act. Now, parties will have to understand. Now, in order to see the reliefs or in order to see the solution, you'll have to see the nature of the commercial operation or transaction, or the particular sector that we are talking about. Uh, so in which industry or sector that you are dealing in, what was the commercial operation or nature of commercial operation or transaction that we are talking about. uh, and based on this, you will have to understand the ambit of contractual clause, which deals with the impossibility of force majeure clause. So that is one important thing to see. The relief and event will depend eventually upon the, as I said, the interpretation of the clause or the contractual provision that we are talking about, and the nature of contract. Now, what will be advisable is that you have to, obviously, whether you like it or not, you'll have to seek a legal help, to avail services of a lawyer or solicitor or whoever legal advisor. You'll have to go through the who with you will go through the contract and the peculiar set of facts of your case, and will consider and then you all will have to consider the risk which is really involved in this entire transaction and contract. And you'll have to explore the possibility in which you will be able to resolve this entire issue with least amount of risk that is really there, and to avoid mutual conflict as well as you causing grave financial losses. So it's better that parties resolve this mutually instead of going to court of law. In case of also, if there is a force majeure clause in your contract, it may provide that you have to give a notice to the other party that yes, there is an event, and because of which I am prevented from taking further steps or performing my contractual obligation. If that is the case, then it will be advisable that you issue that notice to the other party. If pandemic is covered under your clause, then you are in a better footing than the in clause in which the pandemic is not there. So this notice formalities are something that you'll have to comply with in order to avail the benefit of that clause. Other thing, as I said earlier, if there is, you'll have to show that you have taken all the steps that you were required to take to mitigate or avoid this event or the losses that may arise because of this event. So that is something that you have to show the evidence that you have taken steps to avoid losses that you have suffered, or you have made attempt to perform, but you have been prevented from performing your contracts. Now I'll go sector. I'll quickly. I'm sure the time is less, but recently, I think yesterday, the finance minister defined that entire package for the financial package that has been issued of rupees 20 lakh. It appears that the finance ministry has the Union Ministry of Housing and Urban Affairs has issued advisory to state and union territories to declare COVID-19 situation as a force majeure under the Real Estate Regulation and Development Act, that is RERA. Now, why is that important? What the Ministry of Finances has stated that the Ministry of Housing and Urban Affairs would issue an advisory to the states and union territories to the effect in a bid to provide relief for, this is relief for developers. Government has allowed a suo motu, that is on its own, extension of registration and completion date of projects by 6 months for all registered projects, expiring on or after 25th March without individual application. So if your projects which is registered under RERA is expiring on or after 25th March 2020, then it will be extended by a period of 6 months suo motu on its own without the developer to make an application. Now, regulatory authorities may extend it by a period of another 3 months if needed. Fresh project registration certificate will be issued automatically with revised timelines. The center has also directed the extension of timeline for various statutory compliances under RERA. So it's a relief for developers and promoters under RERA. But the only problem is that obviously because of this situation and extension of completion period, this may the handing over of possession of flats may get delayed. So this may have certain friction between, say, a flat purchaser and the developer, because they might be flat purchasers who are living on rent who will have to pay more rent if there is a delay in projects. There are certain flat purchasers who have sold their old premises and are still waiting. And we'll find that in most of, there are very few real estate projects which really get completed on time. So this may cause some friction between the developers and promoters. Developers may also face losses because of these delays, because there may be rise in raw materials, like construction materials, as well as interior materials that is required. Another situation will be that we have seen that lots of migrant laborers are going back to their towns in under unfortunate events. Some have unfortunately have died in this entire, which is very unfortunate, very sad. But there is an exodus of migrant laborers from these big cities to their hometowns. So what we are going to see is that this shortage of manual labor is going to cause a huge headache for infrastructure projects all over India. So that is something that we'll have to consider. Other thing is that lockdown in China is since the beginning of January. So many of these imports of construction materials as well as interior material, it actually happens from China. So they are already facing the consequences of delay of importing these products. So that is also causing a hindrance. So that may result into rising or raising the cost of the project. Now, other aspect is, now this was real estate. The second aspect is that government there are certain directives, advisories, directions which are issued by Ministry of Labor and Employment and Ministry of Finance. The most important, this has been issued, one direction was issued by Ministry of Labor on 20th March to Department of Public Enterprises and also to Chief Secretaries of State to issue necessary advisory to employers, owners for all establishment not to terminate, reduce wages of the employees. So there are these set of directives or advisories which is issued by the government or the Ministry of Labor, in which they have said that private employers or owners of establishments shall not terminate the or reduce wages of employees. And the most contentious one being the government order of 29th March of 2009-20, in which they have directed all the employers, be it of industry or in shops or commercial establishment, is very wide. They say that they shall make payment of wages to their workers at their workplaces on the due date without any deduction for the period during the lockdown, during which it is shut down. Terminate these employees, so which is very important. And there is this whole thing wherein private enterprises are saying that it's not possible for us to be completely operational, because of which now, because of this situation, a certain number of petitions are filed before the Supreme Court, wherein they have said that this direction of the central government or Ministry of Labor is not sustainable. It's void and has to be set aside. We should not be forced to make payment of full salaries to these employees. Now, these I was involved in one of these petitions. I'm still working on it. The Supreme Court has asked the central government to file its reply in 2 weeks, when the matter was listed last. And I think it's supposed to come tomorrow or day after tomorrow. So it will be interesting to see what is going to happen in that petition, whether Supreme Court is going to tell government to withdraw or come out with some fresh policy. On the other hand, another public interest litigation is filed by National Information Technology Employees Sena, in which they are seeking implementation of the same advisory of 29th March, asking the IT firms or IT-enabled firms not to deduct the salary or not to terminate the salaries of employment of their employees. So that is another apprehension. So this is on the other end, wherein the workers and workers association are saying that please do not terminate our services, and the enterprises should be told not to terminate our services. Not petition is also pending between. So it will be interesting to see what stand Supreme Court will take and what will be the stand of government in those two proceedings. Now, the only thing, the other aspect is regarding the HR management that all of us, all the enterprises will have to see in future. Now, let's see the future. In future, the entire gamut of working is going to change. You will say that the cost of worker safety is going to go up. There will be increased labor cost. Some states have passed law that if your employee is affected by COVID-19, then you'll have to give them additional paid sick leaves. You'll have to invest more on the safety. You'll have to invest. There'll be laws in which you'll have to invest in thermal detectors. You'll have to invest compulsory every day on masks, sanitizer, etc., to make sure that your office premises complies with these norms. So this is really going to affect the HR policy of all the companies, all the enterprises. Now, what is important is that Section 72 of Disaster Management Act has an overriding effect on all the laws. Now, Section 51 of the Disaster Management Act says that if you fail to comply with any of the directives that is issued by under the Act, then there is a provision for imprisonment as well as penalty. And what is interesting is that Section 58 deals with offenses by companies. So if the offense is committed by companies, then every person at the time when the offense was committed, who was in charge or was responsible for the company, will be liable for prosecution. So if all the board members and the office bearers will have to be careful to make sure that they are complying with these provisions, otherwise they may face the consequences under the Disaster Management Act. So this is going to be really important for you as an enterprise, or if you are heading an enterprise. Now, there is another provision about, again, as I said, that you may or may not have the force majeure provision. Mostly in these kind of, there are very few such rental agreements in which the landlord or licensor or lessor is in a driving position, that there are very few such clauses in which the clause relating to force majeure is really entered into. So in this cases, whether, as I said, the mere commercial hardship or burdens, the commercial burden is not going to absolve you from these kind of your contractual obligation under the rental agreement. So again, you'll have to sit with your landlord, your licensor or lessor, renegotiate with them. If you can pay in installments, you will have to pay, or you can pay in installments, or you can defer the payment. So this is something, rent reduction or rent deferment, or as far as you can request them to utilize the security deposit, and you can replenish the security deposit in future. So this is something that, as far as rental agreements are concerned, the parties will have to sit and renegotiate. Now we advise, like if I have been advising people, whether they landlords or whether they are licensees, that they should not take any adverse steps which will affect both the parties adversely. It's in commercial interest of both the parties to sit and take a prudent or equitable position wherein both the parties are benefited, in order to avoid any disputes that may reach a court of law. And therefore, it will be in the interest of both the parties to, as I said, renegotiate the contract. Now, M&A deals, the merger and acquisition deals, are also getting affected in most ongoing negotiation. Because of this entire crisis, the value of shares or the value of a company's assets may go down, and the parties have to revisit the valuation that they have done as far as that companies are concerned. And so that has really affected the merger and acquisition deals also. So that we'll have to wait and watch and see and how it really goes as far as these merger and acquisitions are concerned. Parties may again be forced to sit together and see what are the options that they have available, whether they will have to renegotiate the contracts, the entire commercial understanding they have derived upon. So it is affecting the M&A deals also. The other aspect is cross-border trade. Now, cross-border trades are basically these export contracts in which you are exporting something, or suppose, for example, you are importing something, and in this, one of the parties will be a foreign party. So in these contracts, you may have, in these cross-border trade, you may have provision for governing law. So if there is a contract between an entity in Europe, or say, for example, between Singapore and say between India, so the governing law may be the governing law of India or governing English law. So your contract will have to be interpreted based on the governing law that parties have mutually chosen. And will have to be governed as per that law. The other important thing is that we have to see is that, see, this pandemic does not have a uniform effect all over the world. It may have a very adverse effect in one country. Another country may not be really affected by it. So if you have entered into a contract, a cross-border trade or a export contract, or on any other cross-border trade contract with a entity, and if you are supposed, your performance is to be done in other country, which is not really affected by a pandemic that as much as other countries are affected, then the force majeure clause will have to be construed based on the effect of the COVID-19 in that country. So these nuances will have to be considered, these facts will have to be considered, and this is something that we'll have to see what we are going to say. And we may say that once the life goes back to normal after lockdown, we all be constrained to look into these contracts, whether as an individual, I mean, you may be an employee, or you may be giving, as I said, freelance services, or you are into supply chain management, or you are providing any services. So we'll all be compelled to look into these our respective contracts and see how it is going to affect. There might be certain conflicts in lots of these commercial transaction and mobile transactions that we are going to see. So let's hope that we come out of this lockdown without much of wear and tear. And I hope that all of you are healthy, and I hope for recovery of everyone who's affected by this disease, and I hope for betterment of everyone who is being affected, personally, professionally, financially, in any manner possible. Thank you so much for this opportunity to the Mumbai Roadrunners. And if there are any questions, you can ask in the chat right now. Options, even offline, you can reach me and ask you whatever doubts that you have. And I am really glad. Thank you so much for your this opportunity, and I best of luck for everything. Thank you so much. I think there is one question by which has come in the chat, which says, I think Ram has asked this question, that in commercial reality agreement, tenant is not able to use the office premises due to COVID-19. Does it not amount to force majeure? Now, this is what, thanks Ram for this question. As I said, that this is something which will depend upon the interpretation of the contract or the force majeure contract. The inability of a tenant to be able to utilize it is something that we have to see. Force majeure is basically, we'll have to see whether the contract provides for that eventuality. What the landlord or what the licensor may take a position that, okay, fine, the premises is still open, your goods are still lying there, and even if you have an option of either running your business from the premises itself, or you can take your business, you can, as we are seeing, work from home. So it is none of my concern whether you are able to use that premises or not. So the landlord may or the licensors may say that you are using my premises, your goods, your everything, your machines, your fixtures are there in my premises, so I'm more than happy to provide you that situation. But merely because it has become commercially onerous, the tenant may not be in a position to argue that I'm not able to pay. And as far as the inability to enter the office premises, whether it will be a force majeure event or not, is something that will depend upon the interpretation of the contract that parties have entered into. And because you may carry out your work from your premises or out of your premises, and this is all subject to interpretation of the contract, and you will have to justify, as I said, that you were not in a position, or it had become impossible for you, despite making best of efforts, to deal with or to perform your obligations under the contract. So that's what is, as I said, will depend upon the interpretation of the contract itself. If there are any other questions, I'll be more than happy to answer it. And as I said, that it all depends, and that is one of the main problems that we are facing, is the commercial rentals. Manohar has asked a question that if landlord is not in any agreement to waive off rent or reduce the rent, then what will be the way of forward legally? Now, see, the thing is, in such kind of situation, it's better that parties resolve it. And in all these commercial rental agreements, or even for the housing apartments, the leave-in license agreement that we have, a landlord is always in a better position, because all these are very one-sided agreements. Very, like in some of the agreements, you have provision that they can break him open into your premises and take possession of the premises, because it's a mere license. You do not really have any right in the property. So it's better that you do it. And you have to remember one thing, that you have given certain security deposit to him. In a housing agreement, the security deposit may not be much, but in a commercial rental agreement, the security deposit is a lot of amount. And as I said, there are provisions that they can break open and take possession of the property. So one thing, the security deposit is one fact that you really have to see. And the other thing is your fixtures, then various investments that you have made. If it's a commercial premises, various investment that you have made in the commercial, in the premises itself. It may be whatever interiors, your computers, all the infrastructure that you have created. So that is something that you may have, that the tenant or the licensee is in a what do you call it? It's not in a very good position when it comes to these agreements. So it will be better, as I said, to devise to negotiate in a manner. This may be that you can ask him to defer the rent, or to permit you to pay the rent in installments, or permit you to defer the rent subject to payment X amount as an interest or whatever, as penalty, etc. But if you are a licensee, it will be better for you to be in a to renegotiate it, because to take it, if it's a commercial rent, and going to court and enforcing your remedy under that, it's going to be very cumbersome if you are a licensee. Even for licensor, it's not. In commercial case, I have to go into small causes court and taking and getting your remedy, etc. It can become cumbersome. So even the licensor, eventually the landlord or the licensor also wants his money, and they are also reasonable. Most of them are reasonable in understanding the present situation. So they will understand, and if you renegotiate about deferring the rent or paying it in installment, I'm sure that they will really understand. But I will say that avoid going to courts. There are remedies available in both commercial rental agreement as well as in housing leave-in license agreement. But those, they involve lots of time, cost, and other consequences that come with it. Any other questions parties are interested in asking? I'll be more than happy to answer. And anyways, I'll be more than happy to, if anyone has any questions offline, I'll be more than happy to be of any assistance to them. Thank you so much to all the admins and Mumbai Roadrunner for giving me this opportunity to share my views by being as candid and as open as possible. And again, best of luck, and please take care of yourselves and your family. Thank you so much. Bye, and hope to see you on road very soon. Have a nice week ahead, and bye-bye.